meeting, I think. And if the chair would like to take it away.
Thank you very much. This is the June 15th, 2021 meeting of the City of Charleston Board of Zoning Appeals Zoning. Present are Mr. Morrison, Mr. Judon, Ms. Grass, Ms. Richards, Ms. Vargas, Mr. Bennett, and Mr. Robinson. Present from the zoning staff are Mr. Batchelder, Ms. Ashby, and Mr. Valentine. These proceedings are being recorded, and we ask that those who speak identify themselves for the record. We'll conduct this meeting in usual fashion. We'll first receive information from city staff about the application and their recommendation. If the recommendation is favorable and no one objects to the application, usually the Board of Zoning Appeals treats the matter as being uncontested and passes it as a matter of course. If, however, the city recommends against the application or there is opposition to the application, we treat the application as contested and hear from the applicant and anyone else who's in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We'll then make a decision to approve with conditions, or deny the application. The Board of Zoning Appeals Zoning has the authority to do three things. First, to hear appeals to decisions of the zoning administrator. Second, to grant exceptions, a fact-finding function of the board. And third, grant variances of the zoning ordinance if the application meets the hardship test outlined in section 54-924 of the ordinance. The board may deliberate and make a final decision on a matter by a majority vote of members present at the hearing and qualified to vote, provided that not less than a quorum is present and qualified to vote. However, an affirmative vote of 2/3 of the board members present and voting shall be required before a use variance may be granted. For a variance to be granted, the Board of Zoning Appeals must make the following findings. A, that they are extraordinary and exceptional conditions pertaining to the particular piece of property. B, these conditions do not generally apply to other property in the vicinity. C, because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And D, the authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. We have no withdrawals and no deferrals on the agenda tonight, so all the items advertised will be heard at this meeting. First item on the agenda is to review the results of the June 1st, 2021 board meeting. Does anyone on the board have any additions, corrections, or deletions that they wish to make to the minutes? Thank you. Mr. Morrison moves for approval. Mr. Judon seconds. All those in favor signify by saying aye. Mr. Morrison?
Aye.
Mr. Judon?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. The next item on the agenda is 48 Society Street. I will recuse from this meeting, and Mr. Bennett will also recuse. And I'll ask Mr. Morrison to please chair the board for this particular item. Thank you very much.
Thank you, Mr. Robinson. Mr. Batchelder?
So And if we could just get Mr. Bennett in the waiting room, so there we go. Yeah, okay, now we're ready. Okay, so this is a request for reconsideration of the board's decision that was made on May 4th concerning 48 Society Street. The let's see, there we go. The 48 Society Street, just to refresh your memory, is a property that sits on the corner of Anson and Society Street in Anson Borough. And it contains a two-story building that has a history of commercial use on the ground floor and residential upstairs. And the request was to allow, the advertised request was to allow a use variance, but in the course of preparations, I found information that I thought justified treating this not as a use variance, but as a zoning special exception to allow a change from one non-conforming use to another non-conforming use, which is addressed through a different section of the zoning ordinance in section 54-110C. So the board heard that request and made a decision to approve the change to the non-conforming use to allow the salon with conditions. And this is the decision that was signed by the chair of the board, Mr. Morrison, and on behalf of the board. And this is what was sent out. The rules of the rules and regulations of the Board of Zoning Appeals allow for people who disagree with the decision of the board to apply to request that the board reconsider that decision if they file an application and additional document within the 5 business day appeal period following the decision of the board. And that was done. An appeal for reconsideration was filed on behalf of the Historic Anson Borough Neighborhood Association. And this is the document that we received. And this is the information from the Appendix C of the zoning ordinance, the rules and regulations for the board that deal with the procedure for the board to follow in hearing this appeal for reconsideration. So I've highlighted the language so that everybody can see it here, but to grant the appeal for reconsideration, the board must find that it misapprehended or misconceived the question or questions involved, or that it erred in its finding or disposition of the appeal, application, or matter. And if such appeal is granted by the board, the decision shall be withdrawn and the matter heard and considered de novo, as if no hearing, consideration, or determination had been previously made or heard. So that is the language in the rules and regulations for the board. The neighborhood association is represented tonight by an attorney who I will promote to be a panelist, and he will go ahead and give the I think let me see here. So one thing I did not put in here is that I thought I had, but I didn't put it in the slides, but the procedure in the rules and regulations for the board for hearing these is stated in the rules and regulations. So it says, when you have a motion or appeal for reconsideration, that you should hear from me as the secretary of the board. You should hear from the applicant for the motion for reconsideration. And then the board should deliberate and make a decision. You can certainly ask questions of me or of the applicant. I know that the other attorney or other attorneys who both represented the original application on behalf of the owner of the property are present, and also the attorney that spoke on behalf of the prospective salon operators spoke at the hearing. Now, the procedure is not to include them at this point, because this is really a matter for the board to decide based upon the information presented by the attorney on behalf of the application for reconsideration. So I'm going to go ahead and promote Mr. Baker to be a panelist so that he can make that presentation to the board. Let's see, I need to. Okay. I was also told by a distinguished attorney recently that I should not be swearing in attorneys who testify at this board, because of course they don't get sworn in a courtroom, which I'm happy not to do. So unless somebody feels otherwise.
Mr. Batchelder, one little point of order before Mr. Baker gets started. My recollection is that Ms. Richards was absent at the May 4 meeting and therefore didn't participate or vote. So am I correct in assuming, Robin, that you will not be participating on this reconsideration? You can just give us a thumbs up, a thumbs down if you want.
Yeah, I told Robin that she did not need to participate in the vote, but that she could sit in and just listen.
Yeah, we're happy to have her. Yeah.
Yeah, I just will not, I won't be voting.
Okay, yeah.
Yeah.
So that leaves 4 of us with considering the 2 recusals that will be voting on this. And then the required percentage vote to prevail on reconsideration is
A simple majority,
simple majority. Okay,
which in this case would be 3 people.
3 of 4. Yes, okay.
3 of 4.
Thank you.
And thank you for pointing these things out. I also meant to point out that, of course, the decision on May 4th was a unanimous decision on the part of the 4 people on the board who did participate and vote on the matter.
Yeah. Now okay. There's Mr. Baker. Welcome, Mr. Baker.
Thank you, Chair Morrison, members of the board. Can you hear me okay?
Yes, we can. Please proceed.
Thank you for letting me appear this afternoon on behalf of the historic Anson Borough Neighborhood Association. Mr. Batchelder spelled out what it is you're to consider tonight. We do believe that the board misapprehended the question involved and erred in disposing of the matter back on May 4th. I want to make 5 points in that regard. First and foremost, we believe that the public notice was clearly deficient as a matter of law. State law and the board's own rules require publication in a newspaper that gives at least 15 days prior notice. The BZA's own rules and regulations require that notice contain a description of each matter to be heard. The Jackson's application in this case was submitted in March of 2021. For some reason, it was deferred from April and heard in May. But that application, they checked the box that says variance or special exception as indicated on page 2. The application on page 2 has a pre-printed form to fill out whether you're asking for a variance or a special exception. In lieu of filling out page 2, they submitted a letter. That letter clearly stated that they were requesting a variance. It said nothing about this special exception under 54-110C, where you can change from one non-conforming use to another if it's equally or more appropriate for the district. It didn't say anything about that. The agenda item 2 for the May 4th meeting stated request use variance from section 54-203 to allow a salon, etc. It said the agenda item said nothing about that, and we must presume that that is what would have been published in the newspaper, that they were requesting a variance 15 days prior. Now, the Jacksons hired a lawyer at some point. They hired lawyer John Maslon, who's an excellent lawyer, actually a former law partner of mine. Mr. Maslon submitted a letter on behalf of the Jacksons on April 27th, 2021. That was 6 business days prior to the May 4th meeting. We don't know when that was uploaded. So it was probably less uploaded the next day or 2. So there were fewer than 6 days prior to that May 4th meeting that lawyer Maslon's letter got updated. And being the good lawyer he is, he had looked at it and determined, well, the Jacksons, in their belief, had a lawful non-conforming use in this Pixie Lily dress studio and warehouse. And what they really needed was not a variance, as had been stated in the public notice and their application, but simply a special exception to change from one non-conforming use to another. What is important is that it was not published in the newspaper, and 15 days notice of it was not given in any form or fashion, much less as required in the newspaper. Now, at the May 4th hearing, Acting Chair Morrison recognized pretty early on that this notice was an issue. It seems to me, and I've read the transcript, as the meeting wore on, the discussion shifted to whether in fact there had been a lawful continuing use all those years, so you could consider it as a special exception. And the board never really went back to the question of, well, if we can, was the notice sufficient? So that was never determined. So we believe this is a violation per se of the public notice requirement. This hearing should have been stopped, and it should have been properly noticed as a special exception and come back for a hearing, which would have been now. But that's not what happened. We're convinced the court would agree with us. We think it's better for all parties to come back in July with proper notice than in several months after an appeal, and we got to come back because the notice was insufficient. Now, in addition to the notice being a per se violation of the state law and the town and the city's requirements, this insufficient notice is just unfair too. Now, a few HANA members picked up on the posting on the website of lawyer Maslon's letter, but they had only less than a week to gather evidence to oppose this new request for a special exception. But that's also not the test. Most HANA members would not have picked up on the fact that a letter from their lawyer got posted later following the public notice asking for something different. And many of the letters in opposition address the variance issues instead of the special exception issues. Now, substantively, the variance test, which, as you know, is based on hardship, is fundamentally different from this change of non-conforming use. In fact, they're not even comparable. So to consider what's in effect kind of a lesser included request is not fair to the opponents because they didn't have the sufficient notice and opportunity to gather evidence to oppose it. This is
Mr. Baker, I'm sorry to interrupt, but I'd like for us to dwell on this topic a second. Our decision on May 4, as I understood and interpreted it, was about this notice issue was based on the perception of the board that a notice of a variance, and you use a phrase lesser included notice, but the notice of a variance, if I can articulate this, was notice to the public of a potential for a bigger change in the use of the property than would a special exception notice have been, and that anyone concerned about the use of the property would naturally, logically be more concerned and more motivated to oppose and appear and be heard based on notice of a variance than they would for notice of a special exception. And so that was what I believe our thought process was. Could you address that issue, please?
Yes, well, the fact of the matter is to get a variance is very difficult. You've got to prove hardship, et cetera. And so, yeah, it's easier to get the special exception. It's tougher to oppose it. So the evidence you got to gather to oppose the special exception is a lot greater than the evidence you would have to gather to oppose the variance. I mean, frankly, if I had been advising Hannah at the time, I would have said, there's no way they're going to get a variance. Their letter requesting a variance doesn't even address the hardship to them of not getting the variance. And so, you know, it's a matter of, it is the best way to explain it is to contrast it with a situation where someone comes in asking for a variance. An applicant is looking to encroach 10 feet into a setback, okay? And they get to the hearing and the zoning administrator advised them, well, you know, only need to encroach 5 feet into the setback. It's less. So it's might be easier to get, but that doesn't prejudice anyone. When you go from a variance, which is a high threshold test, to this change in non-conforming use, and I'm going to get to my other points too. We don't agree that there was a continuous lawful use of the property, a non-conforming use. And so there's a reduced time period to go get any evidence to prove that. You don't have to prove that in a variance. The variance assumes that they had not had an ongoing lawful non-conforming use.
So are you suggesting that some members of the homeowners association, Hannah, didn't appear to protest the application because they thought it was a variance request and were not concerned that it would likely be granted and would have appeared if it had been noticed properly as a special exception?
I'm not telling you that as a factual matter. The Hannah membership hasn't been, polled on that issue, but that is the logical inference. If I were a member of the neighborhood association and I saw that, I'd say, I know a few other people there go in there to oppose the variance. It's not going to be very tough to oppose the variance. But if they know it was going to be, if they had known that the Jacksons were to contend that this was a continuous lawful use, lawful non-conforming use, and then all we had to do was prove it was equally or more appropriate as a hair salon, I would have, my antenna would have gone up. I would have gone out and figured out whether or not that was actually true, that there was a lawful continuous use, which is kind of my points 2 through 4. So,
Okay, I follow. Thank you. Sorry to interrupt.
No, I invite questions. I think that's the best way to get to the issues. So basically the evidence needed by the opponents was vastly different for what they thought was going to be applied for versus what was granted. It's just not fair to not to have the full notice period to gather that evidence. And my subsequent point, so point 2, it was brought out at the hearing that sometime in the past, the use of the property it changed from Ms. Jackson's father's travel agency, the McIntosh Travel Agency, to Pixie Lily. There was no evidence ever submitted at the hearing that the BZA approved that change in non-conforming use. Just like now, they say they're asking for a change in non-conforming use. The change from the travel agency to Pixie Lily was a change in non-conforming use. Under the city zoning use table, a travel agency would be in Division I, services. A dress studio and warehouse like the Pixie Lily, our belief would be under Division G, retail trade. So they should have, just like they're doing now, applying for, an extension of a non-conforming use because it's just as appropriate for the district. They should have done that when it went from being a travel agency to Pixie Lily. Now, there's actually some reference in Mr. Massillon's letter that he submitted that there was some type of financial services business in there too in the interim. That likewise, there's no evidence been submitted that request from the changing from the travel agency to that interim use was granted by the BZA, which is a requirement. And the failure to get the BZA's permission to change those past non-conforming uses to the Pixie Lily renders the Pixie Lily's use unlawful under the zoning code and prohibits the application of this 54-110C. And that just shows you too why the notice, full 15 days notice, is so important, because but the way things happened with the notice, it compressed for whoever looked and found Mr. Massillon's letter, it compressed the time frame. They could go out and try to get evidence to contest that. That was point 2. Point 3, likewise, and this was discussed at the hearing, but we feel like the board misconstrued this. They to continue the non-conforming use, you've got to be there. You can't discontinue it for more than 3 years, is the most simple way to put it. The May 4th hearing, and in the letter from Attorney Massillon, he said that the travel agency went out of business in 2005. Then the Jackson's application stated they didn't start till 2008. Now, that's 3 years, more or less. We don't know. But if it was more than 3 years, it could be either. We don't know. The record doesn't contain any evidence of that. Then they would have lost the right to try to continue a non-conforming use. That, again, is why the full 15 days was so important, to be able to gather evidence on that. And there's none in the record. And in fact, I've been through it before with the town of Mount Pleasant I appealed to court. The court can send it back for rehearing if the record is not sufficient for appeal. We're proposing shortchanging that by, let's just do it now rather than going to the court and then saying there's no evidence in the record. 4th point, and I'll be quick on these last 2. And this was discussed at the last hearing. There's a serious question of whether there was lawful continuous use based on the lack of a certificate of occupancy for the Pixie Lily. The Jacksons pointed at the last hearing to their 2004 application for a business license. Mr. Batchelder speculated at the May 4th hearing that the CO must have just been lost by the city. But if you look at the facts presented, the Pixie Lily didn't occupy the premises until 2008, fully 4 years after they applied for the business license. It's equally plausible that there's an alternative explanation why there's no CO. It just wasn't needed in 2004 because they weren't going in there yet. And the Jacksons never followed up. They just moved in 4 years later. So these are all questions that there's no answer to, and there was no sufficient time for opponents to try to gather information on that because there was no 15 days notice. My last point relates to the fact that the level of opposition was not adequately conveyed to this board at the May 4th hearing. Early in the hearing, Mr. Batchelder mentioned that there appeared to be, and I quote, pretty overwhelming response of opposition, close quote, to the Jackson's request. The Hannah board members have done an analysis of the letters submitted. There were 49 opposed and 9 in support. As we understand it, the BZA members, y'all never got to review those letters. In addition, then when the hearing came around, 12 spoke for and 9 opposed. And the letters were not received by the members in advance. So, it's just a matter, the level of opposition is a lot greater. And we have over 60 members of Hannah that do request a rehearing of this matter. And that's what we're asking for. We're not asking for the board to reverse itself here. We're asking for a rehearing to inquire into whether there has been a lawful continuous use and what tests should be applied. And then, if we don't like the decision, we'll appeal it, and we might appeal it, we might not. You might come to a different decision when the evidence is fully vetted. But we don't think it has been, and we think it comes back anyway because of the notice issue. That's all I have, but I'll be happy to answer any questions.
I have a question for Mr. Batchelder. I recall that your recommendation on this application was in the negative. Can you remind us how you came to that, to recommend denial of the application?
Well, I considered the information that I obtained from the letters and the and couple of conversations that I had with the adjacent neighbors, and I wanted to, I guess, err on the side of the neighbors, in that I felt like the office uses that had been there, both the travel agency and Pixie Lily, were very low impact. I mean, you hardly knew that they were there kind of uses, in my experience. I mean, I don't live in the neighborhood, but I certainly walk through Ansonboro a good bit, working just a couple. Well, my office is in Ansonboro, I should say. So I spend a lot of time in the neighborhood. And in my experience, I never saw much activity with those businesses that have occupied the property. So I felt like, salon use, people coming and going, would certainly generate more traffic, and so I felt like that was not an equally appropriate non-conforming use. That was where I ended up.
So the analysis that you performed was based on an application for a special exception.
Correct.
And the application that was submitted was for a variance. And I
That's
recall that there was a shift in what we were to decide. And I recall thinking, like, well, wait a minute, if we're going to discuss this test, then the people that are there are not prepared for that test. I recall saying something to that effect, but we just kept, we continued with the meeting on the basis that it was for a special exception. So I would say two things. So am I allowed to give my thoughts? I don't know.
Yes, you are, please.
Okay. So my thought process is two things. So we, from the decision, from the perspective of it being a special exception, I do agree that it's a different analysis. And with respect to the question of the certificate of occupancy, is that the certificate that we were?
So, Ms. Vargas, you are going right now, I would respectfully suggest from the reconsideration issue raised by Mr. Baker, the issue of the adequacy of the notice to a merits issue, which would only need to be discussed in the event we do reconsider de novo. I don't want to cut you off, but I'll just say I don't think it's definite. It's directly pertinent. The notice certainly is.
No, I would agree. I guess I jumped to the second part of Mr. Baker's analysis. We just accepted the fact that there may have been or there was a certificate of occupancy because that was the determination that Mr. Batchelder made. But if we're talking about process and whether the process was correct, I think there's a question about that.
Okay, thank you. With respect to the other participants, Mr. Jodan and Ms. Grass, would y'all have anything to add at this point?
Yes,
Go ahead.
I think that the untimely of the notice, I think that just makes everything mute. I think that's the issue as far as I'm concerned. The notice wasn't published timely. That's my issue. And so therefore it makes it illegal. And process is relevant.
All right, so
Discuss after that, it's almost mute. Need to start over.
Ms. Grass?
I also agree with them that the lack of the public notice of the change from the zoning from a use variance to special exception put the opposition at a disadvantage. And I also agree that what Mr. Baker said about the opposition not having adequate opportunity to speak. I think that, had we heard, we always benefit from more information, I believe, and we always need to hear from everybody. And because they felt like the opposition felt like they were not adequately heard, I believe that they need to be given the opportunity to say, what they think about the application, and that they weren't properly prepared, perhaps because they came to talk about a use variance versus a special exception.
Yeah, and that's the issue I was trying to make is Mr. Batchelder, the application was for variance. But what we heard and the recommendation from Mr. Batchelder was for a special exception. And I think that's the direction that we went. Yeah, the application was for variance.
Let me just state my recollection of the meeting. I think we let everyone speak, as I recall. And we absolutely do have restrictions on how many people and how long we can allow people to speak. That doesn't pertain to letters. We certainly can consider letters in advance to the extent we provided letters. But I will say that I don't necessarily agree that anything spoken by anyone would have been substantially different had the notice been different to them. They weren't making, for the most part, legal arguments, but I do agree that the specifics of the notice, whether it makes any real difference as a practical matter or not, is a matter of complying with procedure, and that we should try to comply with the precise wording of the procedure required of the board. And so I'm inclined to join the three who have expressed concern about the notice, and that would mean, unless anyone wants to vote differently, that we would grant reconsideration and have to bring this matter up and renotice it de novo and all that goes with that. But for the record, we should have a vote here. Ms. Vargas, for or against reconsideration, please.
I vote for reconsideration.
Okay, Mr. Jodan,
For reconsideration.
Ms. Grass,
For reconsideration.
and I join for reconsideration as well. So that is that on this application, Mr. Baker. Thank you for appearing tonight.
Thank you,
Ms.
Board.
Morrison, I'm sorry, Penny Ashby, just for clarification, in terms of the motion, are you saying that Ms. Vargas made the motion?
I will go ahead and make the motion.
Yeah, that'd be good. I'm sorry, Mr. Jodan seconds the motion.
Thank you, sir.
Thank you, Ms. Ashby.
And I guess just a comment on my part, procedurally, I guess we'll get back in touch with all the attorneys that represent the different sides of this issue and confirm when they can attend a rehearing of this matter. And hopefully that will be at the next meeting of the board, which will not be, because you have your summer break coming up, it will not be until July 20th, Tuesday, July 20th. So
You realize, Mr. Batchelder, we've still got a lingering disagreement about what the notice should be. And so,
okay, I don't
You-
realize that.
and I don't think we've decided that or in position to decide that. I think you've got to talk to Mr. Mazelon and Mr. Baker about that, because they disagree about whether the underlying facts would justify one or the other kind of application, as I
Okay.
understand the arguments. And if bad comes to worse, so we can at least be free of this issue of notice, you may have to notice this thing alternatively or something.
Right. Thank you for pointing that out. So if that concludes this item, we can
Yes,
bring our
sir.
other members back. Let's see. There we go. Okay. So let's see. We're all back. Ready to move on to the second item.
We got our trusty chairman back.
He's muted.
Oh, Penny, could you go unmute Mr. Robinson?
There you are.
Good, thank you.
Okay.
Thank you, Mr. Morrison.
Yes, sir, Mr. Robinson.
Item number 2 on the agenda is 1012 Avenue of Oaks, Maryville, Ashbyville. Request an appeal of the zoning administrator's decision to deny building permit on the grounds that the proposed home exceeds the 2.5-story height restriction for the SR-1 single-family residential zone district under section 54-301, because the home's design drive under garage constitutes a third story under section 54-120, zoned SR1. I believe I forgot at the beginning of the meeting to announce the city attorney's presence. Did that come up in the last item?
No, sir.
No.
Did not. Tim Dolman, I am here on behalf of the board to act as your attorney should you choose to vote to go into executive session on this item as well as the next item, which is a related item.
Thank you, Mr. Bowman. Mr. Batchelder.
Thank you. So this is a lot on a street called Avenue of Oaks within a development that's called Avenue of Oaks in West Ashley. It's actually a new residential development within the Ashleyville, Maryville neighborhood. And so just to give you a little bit more information, this is an appeal of my decision not to approve plans to build a new home on this lot because they exceeded the 2.5-story height limit. And this is a view of the zoning map for that neighborhood. And you see the lot in question that is outlined in blue. But there are, I don't know, 30 some lots in the neighborhood overall, I think. And give or take a few. And it's a beautiful piece of property. It actually had a single family home at the very back of the property. And it has a very beautiful avenue of oaks that lead from Fifth Avenue back to where that house stood and or may still stand. I'm not even sure if it's there anymore. But anyway, the house wasn't historic, but the trees were certainly an important feature. The developer went in there and came up with a plan to work around those trees, and it's turned out to be a very nice project. So anyway, the lot in question is not in a flood zone. This is the new map that took effect in January of 2021. The new FEMA map, it shows that this property is in that brown area. This is a flood map, and it shows the zoning, the flood zones, and that brown area is a X zone, which means it's not a zone in which you have to elevate the first floor, and you don't, I don't believe, have to obtain flood insurance for your home. The blue area just outside that lot is a flood zone and does require a minimum elevation of 11, as you can see on the map. And that was a change from the previous map that had this lot in fact, all of the other lots within this neighborhood in a flood zone that required the first floor to be elevated. So the SR1 zoning district that applies to this property has a minimum or a maximum height limit, rather, 35 feet and 2.5 stories. And you can see that highlighted here on the chart from the zoning ordinance. So that means you have to be no more than 2.5 stories and no more than a total height from the curb elevation up to the peak of the roof of 35 feet. And the zoning ordinance defines a story as that portion of the building included between the surface of any floor and the surface of the next floor above it. Or if there's no floor, then the ceiling above that floor. So pretty simple definition. And of course, in a flood zone, where the first floor has to be elevated to meet minimum flood elevation requirements, you end up with homes essentially on stilts. They can be beautiful walls, they can be piers that have infill between those piers, but a variety of ways of constructing those ground level spaces that are compliant with flood zone requirements. And so the house essentially moves from where it would be close to the ground up to a certain elevation above the ground. This is an example of a house that we would call a 2-story or 2.5-story house, with that first floor being a garage storage space, basically a space below the house, below those 2.5 stories, in order to meet flood zone requirements. So that's the way we've interpreted the rules, and we've applied that interpretation since in the city of Charleston since at least the early 1980s, I believe, when the city, through annexation and construction, began to have homes constructed within flood zones. Back when they were brand new, I think they were first adopted by the federal government in maybe the mid to late 70s. So since that time, the city has applied this interpretation where we don't count that ground level as a story, because that would be penalizing the owner of the property by removing essentially a condition from or story from the house. So we've given that interpretation over the years to allow that ground level to not count as a story. And this is the plan that was submitted by the developer, essentially the same as what was on the previous slide. So 2.5-story house elevated above the garage. The only difference in this case is this house is no longer in a flood zone. It is, as I said, it is no longer in this flood zone. So it was in a flood zone up until January of this year, but it's not in a flood zone now. And the reason why I think this is problematic is that granting this appeal would be problematic is that this would be precedential. In other words, if we were to not count that ground level story that is not required to meet flood zone requirements, if we would not count that as a story in those situations, then we would end up with essentially 3.5-story houses, and the city would not really, the zoning division would not have any control over what happened on those ground levels. As we know, garages sometimes end up becoming additional living space. And if that space is outside of the, so even though somebody might say, oh, that's just going to be garage storage space initially, we know that over time, people like to add conditioned space to their homes, and that becomes a convenient place to do it. And you just end up parking outside or something like that. Or you have the garage space and convert part of that garage or that storage level into conditioned space. And the city zoning division would not have any control over whether that happened or not. We don't review building permit applications to make those kinds of interior conversions of buildings. We simply don't have the ability to do that. And it, you know, whether, and there would not be anybody else in the city, the building inspections folks would not have any issue with issuing those kinds of permits to allow those interior conversions for these spaces. So these ground levels that are outside of a flood zone are in effect, in our opinion, a story. If they're in a flood zone, they're not a story, because you're only trying to comply with flood zone requirements set by the federal government, and you don't have a choice in those. But if it's outside of the flood zone, then we consider that to be a story. And typically, the residential zoning districts that have this 35-foot, 2.5-story height limit are the suburban residential developments, neighborhoods that we have all over the city. And you can just imagine all of the homes in those neighborhoods are typically ranch homes, single-story homes, 2-story homes, sometimes 2.5-story homes, not the 2.5 stories over a garage. So we would tell anybody else in those neighborhoods, sorry, you can't build your garage below your house. You don't have to elevate for flood zone reasons. And doing what you want to do, it essentially becomes a 3rd story. So we would not allow that to, and we have not allowed that in the past. In this neighborhood in particular, Ashleyville, Maryville, is typical of many of these older neighborhoods in West Ashley. It's 1-story homes, some 2-story homes. You can see one in the distance here. But to introduce homes on lots where, you know, somebody might come in and say, well, I want to take a vacant lot in this neighborhood, or I want to demolish this 1-story house and build a new house and essentially make it 3.5 stories, would be out of character and create a great impact for this neighborhood. So this would be precedential if you granted this appeal, and would allow homes out of character with these existing neighborhoods in the city that are not in flood zone. And so that, for that reason alone, I just feel like you should really not approve this appeal. I think we've been very reasonable in how we've interpreted the rules in the past and applied them. It hasn't been a problem. Nobody's ever asked for variances or sought to appeal that interpretation. The other thing is that when this first came up, and again, you know, this lot was in a flood zone where the house had to be elevated prior to January of this year. So it wasn't an issue, and the developer constructed a number of homes in other lots in this neighborhood that that had the garage level with the 2.5 stories above it. And we had approved those because of that flood elevation requirement. But now that that's gone, we could not approve the plans for this lot when they were submitted in March. And I subsequently, in a conversation with the developer, advised them that I would be supportive of a variance, a zoning variance, to allow them to build 3-story homes in this neighborhood to continue what they'd already started, essentially, on these remaining lots that where they had planned to do that, but with the flood zone, new flood maps, they were not able to. So I told him I would support that request. And this was right after we had, I think it was right after we had granted, the board had granted the variance for that other neighborhood called Laurel Oaks, which is down, excuse me, down Bees Ferry Road, if you remember, in West Ashley. So that was a similar situation. The developer went through the whole planning process, constructed the infrastructure, was all set to start building homes, and then the flood maps took effect, and that changed the whole set of rules for them, and they had to come in and get a variance. I supported that, and the board approved it. So I feel like this is the solution for this neighborhood. The appeal is a bad solution, and I'll just leave it at that. And I know the attorney who filed this, Mr. Gaskins, is on the in attendance, so if we can promote him.
Lee,
Yes, I'm sorry.
while you are promoting Mr. Gaskins, can you clarify for the board and for me that the next item on the agenda is in fact the variance request, and it is inclusive of this one lot 124 that's mentioned in this request to appeal your decision?
Yes, so the next item on the board's agenda is a variance request to allow a 3-story home on this particular lot that where the lot is located that's the subject of this appeal.
You are going to be, the city is going to support that request.
That's correct. And I see that Mr. Gaskins has been promoted to an attendee. And I guess as an attorney, you don't need to swear you in. So.
Is that your
Thank you,
presentation, Mr. Batchelder?
Yeah, that's my presentation.
Does anybody on the board have any questions for Mr. Batchelder?
Can I ask a question just about a comment that Mr. Batchelder made about the character? Can I ask that now or should I wait?
What was your question?
Okay. I wanted to ask just in regards to one of the points that Mr. Batchelder made about not supporting this request is because the 3-story homes would be out of character with the existing homes in the neighborhood. Is that what
Not in, and so that not in this particular development, but what I'm saying is if you were to agree with the appeal and grant that appeal, you would essentially be establishing a rule that would allow these kinds of houses to be located throughout Ashleyville, Maryville, and other neighborhoods.
Okay, thank you. I was thinking you were talking about that particular development. Okay, perfect.
Right.
Thanks.
Thanks.
Any other
I have a
questions?
question. Yes. Mr. Batchelder, you said that the rules for the flooding zone changed prior to the contractor submitting the application. Is that correct?
That's correct.
Okay, thank you.
Anything else? Mr. Gaskins.
Thank you, members of the board. My name is Brandon Gaskins with the Moore & Van Allen Law Firm here in Charleston, and I represent the owner, Crescent Homes SC LLC. I'm not going to rehash much of what Mr. Batchelder said. I think his recitation of the factual background was generally correct, but I think he did omit some key details, which I would like to highlight. So this development, the final plat for it was approved in March of 2020. At that time, all of the developable lots were in either flood zone AE13 or AE14. So based on that final plat approval and being in those flood zones, that's how the developer determined the layout, or not necessarily the layout, but the design of the homes. And at that time, there are 42 lots in this subdivision. 22 of them were designed to have this elevated drive under garage design. And I believe 13 of those have been permitted, and some have been built and some may be under construction. But that leaves 9 of the original that were not permitted prior to the change in the flood map in January 2021. However, the final plat had already been approved, and that's how the development was designed. So of those 13, there are 13 homes with the same design, same drive under garage style. And under the city's interpretation, that is not considered a story based on where it is in the flood map. And we believe that's an error under the definition of story in the zoning code as is construed as a whole with other provisions of the zoning ordinance. Mr. Batchelder highlighted the definition of story earlier. And that provides in pertinent part, quote, that portion of a building included between the surface of any floor and the surface of the next floor above. There is nothing in that definition that allows the city to determine whether a garage is a story or not based on where it is on the flood map. And one other clarifying point, after the flood map change in January of 2021, this lot, as well as the others, are still in a flood zone. It is in flood zone X. That is a lower risk area, but it is still a flood zone. And there's nothing in writing from the city staff or zoning administrator where it articulates the standard for determining what flood area you have to be in. So we believe that interpretation is arbitrary and capricious and is subject to the whims of the zoning administrator and can change at any time because it is not in writing. But going back to the language of the code and the definition of story, again, it is based on the area between the surface of any floor and the surface of the next floor above. So you have to look to the definition of floor to determine what is a story. And floor is not defined in the zoning code. However, it is defined in the city's stormwater management ordinance. And this is what it says. Floor means, quote, the top surface of an enclosed area in a building, including basement, i.e. top slab and concrete slab construction or top of wood flooring and wood frame construction. And this is the important part. The term does not include the floor of a garage used solely for parking vehicles. So under the city's code, that garage floor under this design is not a floor, and therefore it cannot be a story. The stormwater management ordinance goes on to define the term lowest floor as an unfinished or flood resistant enclosure usable solely for parking vehicles, building access, or storage in an area other than a basement area is not considered a building's lowest floor. So under the stormwater management ordinance, that garage is not a floor, and therefore it can't be a story. And the zoning code needs to be construed harmoniously and as a whole. And when you construe those sections together, it's pretty clear that the garages are not a floor and therefore not a story. So again, we believe that Mr. Batchelder and his department's interpretation of story is incorrect under the plain language of the zoning code. And for the reasons that we discussed earlier, it is also arbitrary and capricious because there's nothing in the zoning code that determines a story based on where it is in the flood map. But I would also add that interpreting story as we have proposed, where a drive under garage is not considered a story, is consistent with the purposes of the zoning code and the comprehensive governmental planning enabling act that says that one of the purposes of a zoning code is to protect property from flooding and other dangers. Here, interpreting story to not include a drive under garage will be consistent with these purposes because it is going to raise the house and protect the habitable area from flooding and the damage that naturally occurs. And I think, you know, the timing of our appeal is very on point because of what we experienced this past weekend. Very severe flooding. And what the city has done and what we saw in the newspaper this week is it's looking to change its zoning code to accommodate these recurring floods. And another thing that it has done in the Dutch dialogues process is looked at ways that we can mitigate the risk of flooding and climate change and rising seawalls. And here we have a development that borders the marshland of Old Town Creek. So there is a flooding risk. And it just doesn't make sense for us as a city to spend all this money to look for ways to mitigate the risk of flooding and then have an interpretation that actually increases the risk of flooding. For those reasons, we believe that our interpretation of story is correct and the zoning administrators is incorrect, and we would ask that you grant our appeal. And I'll be happy to answer any questions that you have.
Any questions for Mr. Gaskins?
What is the overall height of these proposed structures?
That's a good question, Ms. Grass. So regardless of whether whether it's considered a story or not, the height restriction is 35 feet, subject to some exceptions when you are in a flood zone where it can be raised. I believe these are approximately 37 feet, so just above that height, but within the exception that is granted under the zoning code. So regardless of whether it's a story, it can exceed the height of the zoning code.
Okay, thank you.
Any other questions?
I have
guess
a
I-
question for Mr. Batchelder.
Pardon?
I have a question for you,
Okay.
if I may.
Yeah.
Is your recommendation to deny the application a procedural, based on a procedural issue, or is it based on the result of permitting them to build? So is it that the request should have been for a variance?
Well, I disagree with the position that the applicant is taking on this appeal. And there are several things that Mr. Gaskins said that I disagree with. Number one, the definition for a floor is not in the zoning ordinance, so there's no definition. And we've, again, always interpreted that story definition and the term floor in that to mean the floor of a conditioned space. So, you know, you get 2.5, or actually, no, I take that back because that would nullify my position. But I feel like they're arguing with a interpretation that's very reasonable. It's been reasonable and been applied consistently for 40 years. And I've already said that I do support the variance for this particular development because of the situation that they have. So I feel like the appeal is unnecessary. Yes.
Can I respond briefly to that if y'all don't mind? So two things. I don't believe that the city has consistently interpreted the term story in this manner. And if you look at our letter in support with the exhibits, it shows that the interpretation has not been consistent. And I think that further demonstrates why the city's interpretation is so concerning, because it is not based in the text, and therefore they can adopt inconsistent interpretations. I would also argue against the precedential value and the harm that could come from this, because the city, in fact, does have, at least to my knowledge, two specific ordinances: the Cainhoy Plan Development Ordinance and the Daniel Island Plan Development Ordinance, that specifically excludes drive-under garages from the definition of story. So if it's not a story in Cainhoy, and if it's not a story in Daniel Island, and if it's not a story in the backside of this development, how is it a story in the front of the development? So for those reasons, we believe that the city's interpretation is an error.
Any other questions?
Mr. Gaskins, Tim Doman on behalf of the board, as the board's attorney, I'm struggling with the legal advice that I might have to give to the board. I wanted to address Mr. Batchelder's concern that if his interpretation is overruled, then you would have this area that your client might not build out as finished space, but that the homeowners could later come back in and make into conditioned space. And in an X zone, that is not going to be in violation of the stormwater and flood restrictions, as far as I know. And I wanted you to try and help me understand why that's not a major problem.
I don't believe it is a major problem. If it is, I think city council can address it through ordinance to prohibit those types of conversions. And again, looking at Daniel Island, looking at Canoy, if it's not a problem in Canoy, in Daniel Island, it shouldn't be a problem in West Ashley. So I think that's a red herring argument. There's no epidemic of people converting garages to homes and that causing detriment to the community. There's just nothing in the record that suggests that that's a realistic and realistic concern.
So I have one question. I'm still unclear, although Ms. Grass asked about this. This particular application, how tall is this proposed home?
I want to say it's 37 and a half feet, which is within the height restrictions under the zoning code.
And the height
Under the table
restrictions
is
not,
35, but there is an exception to go a little bit higher if you're in a flood zone. And we comply with that requirement.
and so the proposed home is 2.5 stories, well, 2 floors and a half above the garage.
That is correct.
And what would prevent, under your interpretation, Mr. Gaskins, this home from reaching 38 or 40 feet?
The limitations of the zoning code. And the SR1 zoning
And so
code.
this limitation is not 35, strictly 35, as I thought we talked, Mr. Batchelder started with.
It is, I think the default or the general limitation is 35, but there is an exception that allows you to go slightly above that, depending on where you are in the flood zone. And Mr. Batchelder can provide more clarity on that, but it still would be subject to the restrictions in the zoning code. If you adopt our interpretation and say that the first floor is not a story, that does not mean that the developer can come in and build a 2.5 story building on top of that garage that's 45 or 50 feet.
So, Mr. Batchelder, going back to one of your concerns, the 35-foot height limit, if a person were to knock down one of these existing single-story units in the middle of one of those streets, such as the photograph you showed us, and not in a flood zone, and wanted to build a 35-foot home, 2.5 stories that doesn't include a downstairs garage. Say he just wanted tall ceilings. Would that be a home that needs any special exception or variance?
No, it would not.
Okay.
You know, this is a very complicated matter, and we certainly don't want to be setting a precedent, and it might be in our best interest to maybe go into executive session just to ask all the questions that we might have before we make a decision on this case.
I second that.
Well, I can't make a motion.
I'd move for executive
second.
session.
I'll second.
Second, moved and second, all in favor signify by saying aye. Mr. Morrison,
Aye.
Mr. Dion, Ms. Grant,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett,
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. We're going to executive session for discussion and no decisions will be made.
So I think procedurally, I think we have a new Zoom link that all of you were sent, all of the board members were sent. So it should be in your inbox email account near the top. And And I think, I'm not sure how we deal with the.
It prompts you to leave and join once you click on the link. So you got to punch leave and join, which I'm getting ready to do.
So we leave this webinar.
Where is the leave and join? I'm sorry.
I don't see a leave and join.
I'm not very well versed on this part of things, so. Am I able to find that? Okay. No, I left. Let me see.
Oh, I figured it out. So if you click on the link in Mr. Valentine's email, you'll see the leave and join.
Yeah, okay,
How about that?
okay. That's
That easy?
Are we out of the other meeting now?
No, you're not. As far as I know, we're not.
good.
So I think, let me see here.
Let's see. Oops.
So I should just click on the link to open up the new. Okay.
You won't let me read because I'm the host of that other.
So do I start new meeting, leave and start?
Yes.
Okay.
I'm having an issue getting into the executive session.
I'm trying to.
Is everybody else getting an error message that the host has another meeting?
Yeah, I think it's the format that we host these BZA meetings in is not, it allows you to host two meetings at the same time, but we're hosting a webinar for the BZA meeting, so it won't let us host a meeting outside of the webinar. That's the issue.
So can't we hold an executive session by using the same connection here, but by turning off the other participants?
That makes sense.
Or we can set up an entirely separate Zoom conference call or audio call.
Yeah, I mean, I guess we could we could also just do a conference call. We need to get Lee back from where we were. So John, I see you up here. Did you have the same screens?
I did. Yep. Same issue.
And Penny had the same issue also.
Who is this? Oh, heck. Well, we can't get in the executive session. We're having trouble. Okay, thank you. We'll figure this
What happened?
Okay. So that was Edward Pritchard telling me on the telephone that he was somehow in our executive session, which we can't get into.
Oh, okay. So nobody's in there?
Well, there are others, he said, in there who are
That are
not
us.
us, right?
Unless, does he think this is the executive session?
I don't. He could. He's calling me again. Hey, Edward. Okay, so yeah. You can hear me on your speaker now, talking to you on this phone. Okay, thank you. All right, bye. Yes, so we're not in executive session, just for the others who can hear us. We are back to the main meeting now. We don't have Mr. Robinson back yet. Who else are we missing? Have we got Allie Graff?
Ellen. I can text her.
Okay. And we don't have Lee. There's Michael. Okay, but he's abandoned his post. I don't see him. Okay, that was a nice experiment.
I tried calling Penny to tell her we were back over here, but she didn't answer.
Okay. Tim may be able, Doman may be able to send us all a conference.
Yeah, that's what I'm trying to find, though. I usually make somebody in my office set that up. So let me see what I can do to find out how I can get that conference call number.
Tim?
Yeah.
I can actually do this. Once we get everybody on here to listen, I can give everyone a dial-in number without having to email them and a passcode.
Well, you don't want to do that in this. This is a public meeting now. So
Yeah, that's true.
you can email it to everybody,
Yeah.
and then you'll be able to go into that.
All right, I'm gonna try to do that right now. Bennett, Dillman, Ashby, Lee, Mike, Walter. Walter, this is your email, abstractor93.
Yes, it is.
Okay. So I'm gonna send everybody an email with the dial-in.
So it's important that everybody go to mute on this and not be on your phone while you have an open line to the meeting
Yes.
otherwise.
Yes, exactly. All right, I'm sending this now. And I'm going to mute myself and I'm going to host. I'm now identified as Penny Ashby.
Hal, did you get my email in there too?
Okay, I received Mr. Morrison's email. I'm going to get on that line.
I'm not sure that he didn't
No,
say my name.
Yours is not on here. I get it. Stand by a second, please, Robin,
Okay.
because I'm in the middle of
Now, enter the matter number. Please wait for the tone. Then say your name and press the pound or hash key.
Howell.
When you hear the tone, you will be the first person to join the meeting.
Robin.
Another person joins.
I thought I was joined.
What is your email, Robin?
It's ROBBEN Richards at Comcast.net.
Yes. Okay.
Got it?
1 second, please. All right. It's gone to you.
Okay.
And I am remuted. Michael, you need to be muted, maybe with Penny's help. Okay.
I have the
Yes,
meeting.
thank you. And everybody's muted. Walter, are you muted?
No, I just unmuted myself. I have the meeting ID number, but what telephone number do I use?
It's on the email. It's 888. It's at the front of the email. Oh. The email I sent you, Walter, can you hear me?
Joining the meeting.
Mute doesn't work. Press Alt-A to unmute. Hold on, Walter. Alt+A.
I see it.
So do we do this on Zoom?
Robin, you should have received in your inbox.
I have it, but what do I do with all those numbers? I just click it on my phone or on the iPad?
Yeah, you call the number and then you put in the passcode.
Okay.
Yes. Oh, no, not on the Zoom.
Robin Richards. Yeah.
Okay, mic is set up though, right? Okay, all right, good.
Wonderful, thank you. Yes, sir. Are we back in the meeting yet, Lee?
Yeah, Lee's muted. Mr. Jordan's not back yet. There he is.
All right.
Is that everyone?
Penny, need Penny.
Yes, Penny.
There she is. Okay.
All right, we're out of executive session and we received legal advice. No decisions were made, just received legal advice on this issue. We're on item number 2, 1012 Avenue of Oaks. Does any member of the board have any other questions for the appellant or for Mr. Batchelor? Are there any motions?
So, Mr. Chairman, can we move to defer and go to number 3 until we've heard number 3 on our agenda?
Is that your motion?
I'd like to make the motion if it's proper, yes.
Is there a second to that motion?
A second.
All in favor signify by saying aye. Mr. Morrison?
Aye.
Mr. Jadon?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Item number 3 is the Avenue of Oaks, Maryville, Asheville. Lots 1 through 7, 16, and 42. Request variance from section 54-301 to allow construction of 3-story single-family residence on lots 1 through 7, 16, and 42 that exceed 35 feet in height. Limit is 2.5 stories, 35 feet, zoned SR1. Mr. Batchelor.
Thank you. And I'll just point out that where it says 25 feet on the screen right now, that's a typo. It should say to exceed 35 feet in height. So this is the variance request to allow Crescent Homes, the developer of this neighborhood at the Avenue of Oaks, to construct these taller homes on the lots shown on this map. I think that's 9 lots total. And again, just going back over this, so this neighborhood was started, and when it was started, the flood maps had all of this neighborhood in a flood zone, and other homes in this neighborhood were constructed. Not all of the homes, but other homes were constructed that exceed the 2.5 story limit and actually have the drive under garage and exceed the 35-foot limit by 2.5 feet. So this is a list of the specific lots that are listed in your agenda, and these are the lots where they're requesting variance. And this is the zoning map, just showing that all of these lots are within the SR1 zoning district. This is the old flood map. I've highlighted the lots in question. And the AE 13 zone is what applied to this area prior to the change in the flood maps. The new flood maps have this brown area, which is an X zone, does not require any flood elevation for lots within that X zone. The blue zone is a flood zone, does require some elevation, but not as much as the old flood zone. So they submitted their application and the paperwork. This drawing right here does a good job of illustrating that what they've constructed so far. So the pink lots, the lot numbers that are highlighted in that pink color, those have been completed. Those homes have been completed or are under construction, I guess, potentially. And those are drive under homes. So those are the taller homes. The yellow homes are not drive under homes. Those are, I guess, 2-story homes on a raised foundation. And then the blue highlighting indicates the lots where they're requesting the variance. So as I said in the previous matter, I support the variance to allow this neighborhood to go ahead and have those drive under homes constructed, essentially a 3-story, 3.5-story home constructed on these lots, and with that total height to exceed the 35-foot limit by 2.5 feet. That will allow them to complete the build out of this particular neighborhood, which was started under the old flood maps and under the new flood maps is impacted with the restriction that we've been talking about. And this would be consistent with what the position that I took on Laurel Oaks back in early May when that matter came before the board, and the board approved that variance request. So I recommend approval of this request.
Mr. Batchelor, I noticed on the application that it talks about the buildings exceeding 35 feet in height, but it has no parameters and no distances that might be exceeded. Is there anything more information on the applications that gives us a little more guidance on that?
Well, the elevation that they did provide shows a 37.5 foot height limit. And I think they also indicated that somewhere else on a drawing, this drawing right here, which shows the 37.5 foot max height for these homes. So that's the extent of the request to increase the overall height above 35 feet.
Any questions for Mr. Batchelor?
So it would include a not to exceed 37.5 feet.
Correct.
Would be part of this approval.
Correct.
Ms. Ashby, is there any opposition to this request?
No, Mr. Robinson, I'm not aware of any opposition. No one has signed up to speak against it.
Are there any motions from the board?
I move for approval with the conditions that the limit be set at 35.5 feet and that the ground floor cannot be converted into conditioned finished space.
You mean, you might have meant
30.5 feet, John?
I'm sorry.
37.5 feet, not 37.5.
Correct. 37.5 feet. Thank you.
Is there a second?
I'll second.
All those in favor signify by saying aye. Mr. Morrison,
Aye.
Mr. Judon,
Aye.
Ms. Grass,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett,
Aye.
Robinson votes aye. The motion is unanimously approved. And I believe Mr. Morrison, your prior motion was to defer the hearing of item number 2 until we heard item number 3. Was that correct?
Yes, sir. So item number 2 has been granted, that variance has been granted by number 3, as I understand it. And I'm not sure we need to consider 2 in as much as the plan has been permitted by variance. I mean, but yes, by variance number 3.
Is there any discussion on that?
Mr. Chairman, may I be heard on that point?
No, sir, we've closed the public hearing portion on that item already. Is there any discussion from the board, please?
Yes, I have a question. So in other words, what you're saying is that because we voted yes for number 3, then number 2 will be permitted? Is that what I'm hearing?
It was one of the lots encompassed in number 3.
Okay.
What was the intent of the scope of your comment, Mr. Morrison?
Well, it seems to me that the board does not need to decide number 2 if the plan for 37.5 feet is approved for number 3. For that lot at 1012 Avenue of Oaks, item number 2. That issue becomes mooted, does it not? For purposes of our decision?
Yes, but number 2, isn't that violates the federal flood zone? Is that correct? Because the application was not submitted prior to the government rezoning of that area. I think the application was submitted in March.
Well, I'm a little bit lost. I thought it was not in a flood zone.
You're correct. The lot was in a flood zone until January, and then it was removed from the, it's still in an X zone, flood zone, but it's not in a zone that requires the first floor to be elevated. Let's put it that way. So it no longer qualifies under the previous decisions that the staff made regarding the other lots where they did receive city approval for drive-under homes. And those are the lots shown in pink here. So, yeah, so they're just, so that number 2 is specific to one lot in this neighborhood. The variance that you just approved will allow them to construct the home that they applied for back in March.
Does that clarify for you, Mr. Udon?
Yeah, somewhat.
Any other questions, any motions?
Well, I guess procedurally, I'd move to defer number 2, Mr. Chairman, on the grounds that I think it's mooted. If we get legal advice, we've got to decide that. We can revisit it at another meeting. But I don't see the necessity of deciding an issue that complicated if we don't have to.
Is there a second to that motion?
Second.
All in favor signify by saying aye. Mr. Morrison?
Aye.
Mr. Udon?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Thank you very much. Next
Excuse
item
me,
on the
Mr. Chair.
agenda is number 2, Anson Street. Request third one-year extension of a vested right pursuant to section 54-962 that expired on December 31st, 2020. Vested right pertains to a special exception granted under section 54-220 on February 2nd, 2016 for a 50-unit accommodations use with conditions in a GBA General Business Accommodation Zone District. Mr. Batchelder.
So this is a request to extend the vested right that already expired. It expired on December 31st of 2020. And this concerns a property on Anson Street, number 2 Anson Street. And it's within the accommodations overlay. It was approved a few years ago for an accommodations use on this property. And that was the vested right that expired on December 31st of last year. So section 54-962 of the zoning ordinance, which speaks to the term of a vested right, specifically says that upon application by the landowner of property with a vested right, at the end of the 2-year vested right term, to the local governing body that approved the site-specific development plan, which in this case was the Board of Zoning Appeals, the term shall be extended on an annual basis for up to 5 annual extensions. And we've of course heard many requests to extend vested rights, grant 1-year extensions to vested rights that had not expired. We routinely approve those. However, we've not heard one like this for a vested right that is expired. And my position would be that the board doesn't have the authority to grant such an extension when the vested right has expired. You have the right to grant an extension for a unexpired vested right and have done that many times, including, as I understand it, and Penny can correct me if I'm wrong, but we granted 12 extensions to vested rights. The board granted 12 extensions to vested rights last year over the course of that year. So, and we've already granted a few this year and we've got more coming. So this has been a typical thing that we've done, but we've not heard this kind of a request to extend a vested right that is expired. So our position is that the board's not entitled to grant this extension because this vested right has expired.
The city recommends disapproval. Is the applicant present?
And Mr. Walker is the attorney representing this application. And I know he was on the call. I'm looking for him.
While you're looking for him, Mr. Batchelder, could you tell us when the application was submitted? To read?
Oh, yes, that's a good point. So, well, let me see. So this is the application that we received. It's dated May 14th of this year. And I see Steve Ramos. I'm going to promote him to be a panelist.
And Lee, I'm on. Can you hear me?
Oh, great. Yes. Thank you. Okay.
Mr. Walker.
Thank you very much, Mr. Chairman. Thank you, Lee. As Lee said, this is an application for a one-year extension of a special exception that was granted back on February 2nd, 2016. It has previously been extended 2 times. The last time it was extended was in 2019 with an expiration date of December 31st, 2020. As we state in our application, there was an attachment, by the way, explaining the grounds for the request for extension. There are multiple reasons that we would assert that would justify the late approval. And the first thing that I would say is that we're not seeking anything more than we would have been entitled to had we applied on time. As the board knows from going over these extensions many a time, the extension is automatic. It's not an application that requires deliberation. The statute and ordinance require that it be granted unless basically the approval is against the law at the time the extension is requested. Here, there's no question that we missed the deadline. And as we say in our application here on our various points, that it was during the coronavirus, the pandemic. It was missed, frankly, because of disarray. We don't have a legal reason for having missed it other than the pandemic. As we note in our grounds, the legislature of South Carolina has already begun a bill, or there's a bill pending to recognize these permits that were alive at the end of the last year in order to extend them. That bill has not been passed, but it's under consideration. And here, I think it's important not only that the application would have been granted, it would have been rubber stamped, but that we're not seeking to extend it any more than if we had applied on time. And Lee, if you'd be so kind as to put up your slide on the governing ordinance within the city, because that wording is really important. There you go. So if we take a look at this ordinance, it states in the highlighted sentence, upon application by the landowner of property with a vested right at the end of the 2-year vested right term to the local governing body that approved the site-specific development plan, the term shall be extended on an annual basis for up to 5 annual extensions. Now, one thing that's important is that it does not say that every annual request for annual extension must be submitted before the expiration of the then existing annual extension. It says that the annual extensions are granted if the property owner makes application before the termination of the first 2-year period. The owner did that, and the owner was granted the extension once. The owner was granted it a second time. It's our position that this particular wording does not require that we put in the application before the expiration of an annual extension. It just doesn't say that. We recognize that there could be concerns that the interpretation that I'm suggesting could be abused, but here we have extraneous circumstances or extenuous circumstances with the pandemic that we think would warrant special consideration. And we respectfully disagree with Mr. Batchelder in his statement that there would be no authority to do this. We don't think that this board or the city intends to do a gotcha here. We gotcha. You didn't apply in time despite the pandemic. You're gonna have to go back to go again. It would have been granted. And as was stated earlier, we think a reasonable approach would be to grant it. There's no harm, there's no prejudice in granting it, to the extent that someone might say, oh no, we're going to grant a terrible precedent. I think that the circumstances that we present could easily be distinguished. And I would say if somebody else came in the same position with the same case, that an extension would be warranted for that property owner as well. So we would respectfully request that the board consider our application for the extension of the 1 year, for the extension of 1 year that the board would have granted had we asked in time and under circumstances where there is no prejudice, but there would be extreme prejudice to the owner if it were not granted. Thank you, Mr. Batchelder. Thank you, board members.
Any questions for Mr. Walker from the board?
Yes, I have a question. Mr. Walker, should the board approve this, would the extension be up for renewal again on the same schedule? Or would it be in a year from this date, in which case you would actually be at 5+ years by the time you'd extend all the way through all the potential annual extensions?
Very good question. No, we are simply trying to get an approval effective as of, I guess, the 31st of last year. We are agreeing that this one expires at the same time it would have expired if we were on time. And we are not trying to capitalize and get 6 more months out of this. All we want to do is to be in the same position we would have been in. And yes, we will have to apply before, believe me, we're going to apply before the end of the year this year.
Thank you. That answers my question.
Mr. Walker, I'm having difficulty, to be honest. The legislature obviously sees there could have been some potential problems because of the occurrences over the past year. And they're trying to set it right and maybe give boards like us the legal authority to do something about it. But I'm having difficulty seeing that we have the legal authority to do anything. If you need an extension, I mean, it just comes to reason that you file for that extension prior to the time that your time frame ran out. So I can't see the reasoning behind not having to file before it does run out. I can't overcome all that.
Mr. Robinson.
Well, what if, let me just ask a hypothetical. What if there is a man in the office whose sole job it is to keep up with deadlines such as these on a calendar? And that man died 3 days before the end of last year from the pandemic. And his job wasn't filled for another week or two. And this applicant had come in here 4 days late after the deadline and applied for this renewal. Those would be, and I would submit, the kinds of extenuating circumstances that we'd be hard pressed not to act on. I mean, there's no, I can see this both ways with the pandemic myself.
Mr. Walker, you were getting ready to respond to my question.
Thank you, Mr. Robinson. What I was going to say is that the legislation that's under consideration automatically grants extensions without having to go back to the board that granted the site-specific development plan. So it's self-executing, and there's nothing in that legislation. And the bills are attached to the application that would in any way prevent this body from granting equitable relief considering the circumstances.
Legislation, I'm not familiar with that legislation. Would that be self-curing for an issue such as this?
It would be the same as the legislation that was passed during the recession. You may remember that the legislature had 2 joint resolutions during the recession. One, I think, in 2010, and another in 2013, that in legal terms told all the permits and approvals during the Great Recession, so that the time of the Great Recession was not considered for purposes of the running of those approvals, and the bills that are in the legislature right now that were attached to the application and part of the package are similarly drafted. And those, as I said, automatically extend and toll the application. Excuse me, the approval.
Those, yeah, yes, sir. I know what you're talking about there, but so they're slow on the trigger here on this one, I guess, and getting it out.
They are, and there's been a lot going on in Columbia with Santee Cooper and other things, but I can't tell you when it would be passed, because the business session of the legislature is over, so it would be next legislative term.
Any questions for Mr. Walker? Any motions?
And before you get to that point, I just want to mention, if I could, that I know, I think we have a representative from the Historic Charleston Foundation that would like to speak, if that's correct, Penny.
Yes, sir, it is.
And then we also have a letter from the Preservation Society, which I'll just briefly mention, that they support the staff recommendation for denial of an extension of a vested right. Approval expired on December 20th, therefore is not eligible for an extension. And this is signed by Aaron Minigan, Director of Historic Preservation for the Preservation Society. And if the board would like, I can unmute, or we can unmute Cashin to speak, or allow to talk. Okay.
Thank you, Mr. Batchelder. Good evening, Mr. Chairman. And
a moment, please. Lee, would you please swear in the?
Okay. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
yes, I do. Mr. Chairman and members of the board, Cashin Drolet, Historic Charleston Foundation. The foundation opposes this agenda item for a one-year extension for vested rights for 2 Anson. We believe that the ordinance requires renewal on an annual basis, and we don't believe that the board is empowered to approve this application. Last year, despite the pandemic, the city received numerous timely applications for extension of vested rights, including those for accommodations uses. Bolstered by the virtual meetings ordinance that was adopted by the city in the spring of 2020, the BZA missed only 5 meetings in 2020 due to the pandemic and resumed its ordinary meeting schedule on June 2nd, 2020 through the end of the year. Thus, we believe these applications are kind of out of the ordinary. HCF is very concerned that approval of these applications for vested rights that have already expired would establish a dangerous precedent. And respectfully, we would ask members of the BZA-Z tonight to deny the application. Thank you.
Thank you. Anyone else?
No, Mr. Robinson.
Mr. Walker?
Mr. Robinson, thank you. I'm not going to, I think you've heard it, and it's getting late in the evening, so I will waive any reply. Thank you.
Thank you.
I have a suggestion for the board. In view of the fact that it is possible that the legislature may come back into session before the end of this putative renewal period and pass this bill that's under consideration retroactively. Why can't we defer this application until December, for example, to see if the legislature takes action which would effectively moot this issue and hold it undecided until then? Does anybody have any thoughts about that? That way we wouldn't have to decide our authority here or make a decision that might run contrary to what the legislature could do during this renewal period.
Well, I'm not the attorney, but I am concerned about that since we have been given direction by Mr. Batchelder that we don't have the legal authority to extend it beyond the 5-year period. And I guess it just concerns me to defer it based on the legislation that might not occur. And would that set a precedent for other applications to do the same thing, since we have the information now that we don't have the legal authority to extend it? Is it appropriate to consider the legislation, pending legislation?
Well, we do have the authority to defer it, like Mr. Morrison suggests, and it could be possible that we will be given authority later in the year, like he suggests, to approve something like this. So deferral sounds like might have some reason to it.
Well, with all due respect, I do agree with Lee that it's setting a precedent, and I think we've heard many vested right cases, as Lee said, maybe 12. I think that, from December 31st, 2020 to May 14th, 2021 was 4 months that we didn't hear about this application. And I feel like the application should be denied.
Any other comments? Mr. Morrison, was your prior comment a motion, or were you?
Well, I was kind of looking for the sense of the board. I'll make the motion anyway that we defer this application until the December agenda.
Is there a second to that motion?
I will second that motion.
Seconded by Mr. Bennett. All in favor signify by saying aye. Mr. Morrison?
Aye.
Mr. Judon? Mr. Judon? Ms. Grass?
Nay.
Ms. Richards?
Nay.
Ms. Vargas?
Nay.
Mr. Bennett?
Aye.
Mr. Judon? Mr. Robinson votes aye. So we right now have a deadlock. Mr. Judon?
I don't see him in the meeting. He is not listed as a panelist any longer, so make sure.
Well, he's not available for voting, so by virtue of a tie, the motion does not carry. Is there another motion?
I move for denial of the application.
Ms. Richards moves for denial. Is there a second?
Second.
All in favor signify by saying aye. Mr. Morrison?
Nay.
Mr. Judon? Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Nay.
Mr. Robinson votes aye. The motion carries by a 4-2 vote. Thank you very much. Next item on the agenda is 40 to 46 Market Street. Request third 1-year extension of a vested right pursuant to section 54-962 that expired on December 31st, 2020, vested right pertains to a special exception granted under section 54-220 on February 2nd, 2016 for a 50-unit accommodations use with conditions and a variance granted from section 54-306 to allow a 3-story building in a GBA, General Business Accommodation Zone District. Mr. Batchelder.
So this application concerns the same exact circumstances that we just heard for 2 Anson Street. The vested right for this project expired on December 31st of 2020. And the application, let's see, was filed May 14th, 2021. And so my position remains the same, that the board is not authorized to grant an extension in this case for a vested right that is expired. And we have the same letter of non-support from Aaron Minigan of the Preservation Society. And I think Cash and Drolet had signed up to speak on this matter as well. And I think all of our positions are the same that you just heard on the previous matter to Anson Street. So the board would like to hear from Mr. Walker. He's still a panelist.
Mr. Walker, do you have any comments?
I believe. Keep going. Yes, there he is.
He's gone.
Thank you, Mr. Batchelder.
Here,
Chairman Robinson. Lee's correct that the question on this particular application is on all fours with the last one. The only comment that I would have is based or in response to the comments earlier, and that is that we do believe that the board does have the authority to grant this extension. There's nothing that prohibits it, and the wording of the ordinance that we reviewed did not prohibit it. That's all I have. I'm not going to impose on you anymore. Thank you.
Is there anyone present who wishes to speak in opposition?
I just want to double check. Mr. Jourdan is still not present, is he?
No, he's not present.
Okay, thank you. I have nothing more.
Any opposition, Lee?
Mr. Olay is still on, so I've allowed her to speak if she would like to make her comments.
I'm
Mr.
here.
Lay, you're still on the oath. Please proceed.
Thank you. Mr. Batchelder, thank you. Mr. Chairman, members of the board, Cash and Drolet, Historic Charleston Foundation. We also oppose this application, similar to our comments before this application. We don't believe that the BZA is empowered to approve this application. We think it would, again, establish a dangerous precedent, and we would respectfully ask the board members to deny this application as well. Thank you.
Thank you. Mr. Walker?
I will cede my time. My response would be the remarks made in my opening presentation in the prior application. Thank you, Mr. Robinson.
Thank you. Is there a motion?
I'll move for denial based on same reasoning as before.
Is there a
Second.
second?
I'll second.
Moved by Ms. Grass, seconded by Ms. Richards. All in favor signify by saying aye. Mr. Morrison?
Nay.
Mr. Jourdan? Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Nay.
Mr. Robinson votes aye by a vote of 4-2. The motion carries. Thank you very much. Next Next item on the agenda is 125, 127 Smith Street, Radcliffe Borough. Request special exception under section 54-110 to allow a property line adjustment that reduces the non-conforming lot area for 125 Smith Street from 2,556 square feet to 2,173 square feet and increases the non-conforming lot area for 127 Smith Street from 2,431 square feet to 2,814 square feet, 4,000 square feet required. Request a variance from sections 54-301 for 125 Smith Street to allow 42% lot occupancy and 7-foot total side setback, 35% limit, existing lot occupancy 36%, 15 feet required. Request special exception under section 54-501 to allow construction of a single-family residence on a lot of insufficient size at 127 Smith Street. Lot area 2,814 square feet, 4,000 square feet required. Request variance from section 54-301 to allow construction of a single-family residence at 127 Smith Street with a 1.5-foot south side setback, a 13-foot total side setback, and 44% lot occupancy. 9 feet, 15 feet required, 35% limitation, zone DR1. Mr. Batchelder.
So this is a application that concerns 2 lots side by side on Smith Street in Radcliffe Borough. The lot on the south side, 125 Smith, is a lot with a home on it, single family residence. The other lot is a vacant lot. And the applicant owns both of those lots. This aerial view shows the lot with the home on it. And you can see just to the north, the vacant lot. Here's a zoning map showing both zone DR1. These are photographs that show the existing house on the left and the vacant lot to the right, which it appears that it's just part of a yard for the existing home, but it's actually a separate lot and has been for many, many, many years. And the other thing I'll point out about this is that the house on the left, the pink house, that was relocated to this property from another location. I think it might have been moved here when Ashley Hall expanded many years ago. But it has the porch, the piazza, on the north side of the house instead of the south side where it should properly be. So the house was moved somewhere from a situation where that piazza was probably on the south side or the west side, and now it's on the north side, and the very narrow side yard setback is on that south side, the other side of the house, opposite the porch. So that's a unusual circumstance, and it affects the proposal to build a new house on this vacant lot. But essentially, the request is to shift that existing property line that separates these 2 lots to the south. And so on this map, you'll see this is the existing property line. This is the existing property line right here, this bold line right here. And the dashed line is the new property line location. So they're adjusting that property line, reducing the size of 125 Smith Street and increasing the size of 127 Smith. That is the first request on your agenda. That's the special exception to change the non-conforming lot sizes. Second request has to do with 125 Smith. By shifting this property line over here, you're reducing you're increasing the overall lot occupancy of the building on the lot and decreasing the side yard setback And that is the second request that has to do with the variances for those two items. Third request is a special exception to allow this vacant lot, now a slightly larger lot, to have a home constructed on it. It is a lot of insufficient size and the zoning of the property, only 2,814 square feet with the adjustment in the lot line. So we recommend approval of that, of course, because this is a lot that is appropriately sized for that neighborhood, even though it is smaller than the minimum lot size for that zoning district. It's typical of the lots in that immediate area in size. And finally, the final request is the variance to allow the footprint of this new home shown here on this lot with setback variances and lot occupancy variances. And so those are the requests. I'm supportive of this request, and I will say that the applicant reached out to some of the neighbors and the homeowners that live back here. I believe they're 5 Talon Court, are supportive of this request, and James and Kathy Lip, and that's Quinn and Alex English, who live at 5 Talon Court, and then James and Kathy Lip, who live at 129 Smith, which is directly to the north. If I go back to this view, so this house over here, this is 129 Smith Street. They are supportive of this request as well, and they've indicated that with their signatures. So, and the 5 Talon Court is the house that's back here. You can barely see it through the trees. So that is in effect the nature of the request. I'll just show you a few more slides that show the floor plans. The house has to be elevated because it is in the flood zone. And the lot is within the BAR's jurisdiction. So the design of the house will have to be reviewed and approved by the BAR. But that is in effect the nature of the request, the details of the request. And I support all of these special exception and variance requests. I feel that they meet the special exception requirements, and the change in the non-conforming lot sizes is equally appropriate, I think. And the proposed location of this house is suitable given the fact that you have this odd juxtaposition of the 2 homes on either side, with the north-facing piazza on the south side, and then to the north you have driveway and basically a blank side there. They're proposing to put their driveway right in here. So anyway, I'm supportive of this request. I think there may be some opposition. I do have a letter of opposition, and I don't know if there's anybody else, but I'll just read this one letter of opposition. This is from Aaron Minigan, the Preservation Society, and he writes that the Preservation Society is opposed to the various special exception variance requests for this property. The significant number of requests indicate the proposal is too out of character with the district, and we believe will be a detriment to the adjacent historic building. We encourage the applicant to work more with zoning, within the zoning framework of the existing lot at 127 Smith, to be more in keeping with the streetscape character and provide footprint more sensitive to the neighboring historic buildings. I think that the BAR will certainly review those items and have a lot to say about it, and possibly approve this design. We'll see, but I leave that up to them. So that concludes my comments on this, and I don't know if there's any other opposition or anybody else that signed up to speak on this matter other than the applicant.
City recommends approval. Ms. Ashby, is anyone present who wishes to speak in opposition?
No, Mr. Robinson.
All right. Are there any questions for Mr. Batchelor or any motions?
Mr. Batchelder, I'm sorry to ask this, but everything seems to be hard tonight. Can you go over again how the location, unusual location of the piazza affects your recommendation? You lost me on that.
Well, if you put this proposed house over here along this north side property line, then the side yard for that house will be facing the piazza of the house to the south, which, you know, that's going to be where you see people the most on that property versus this house over here having just a driveway, no entrance, few windows, but not many. So I think the yard for the proposed house being on the north side, adjacent to the driveway and essentially a blank wall on that south side of that house to the north, makes more sense than facing the house with the piazza on the south side. So that's my thought about that, and why I think that let me go this way. Proposed driveway over here and entrance and all that sort of thing over there, and plus it ties in better to where the backyard is for this house, which is back here behind the driveway and the house. So it basically becomes an extension of the driveway, whereas if it's over here, it's not. So that makes sense, I hope.
You know, I'd like to address the Preservation Society's comments, and it's something I look at many times as to the number of variances or special exceptions any one application is carrying. In this particular case, we're dealing with 2 lots. And so it might necessarily bring on a more variance requests than normal. And I think in this particular case, I can see the need for that. And anyway, I just wanted to comment on the numbers of variance requests. And you know, if you got 2 lots you're dealing with, you necessarily are going to have more needs for variances.
And the applicant, I should just point out, I'm sorry to interrupt, but the applicant is on the call here, and I can certainly promote him if you want to hear from him.
Are there any questions from the board or any motions?
I'll move to approve.
Move approval. Is there a second?
I'll second, but I mean, we're approving special, the motion is to vote on both variances and the special exception, which have different voting requirements.
No, you can vote on all together if that's what the motion is. Does the motion cover all 3 requests?
Yes.
Okay, I second.
Moved and seconded. All in favor signify by saying aye. Mr. Morrison?
Aye.
Mr. Udon, is he back? Ms. Grass?
Aye.
Ms. Richards? Ms. Richards?
Aye.
Thank you. Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Next item on the agenda is 40 Savage Street, Charlestown. Mr. Bennett will recuse from this item. Request special exception under section 54-110 to allow a horizontal expansion, kitchen expansion, bedroom, and vertical extension, master bedroom, suite, closet, stairs that extends a non-conforming 1.9 foot east side setback and non-conforming 3 foot rear setback, 3 feet and 25 feet required, zone DR1F. Mr. Batchel.
This concerns a residential property south of Broad Street, and the fairly simple request. So you see on this aerial view, this is the house, and you see that it's set way back in the property. So there's very little backyard and large front yard. Unusual because most of the homes on Savage are set up closer to the front property line, if not at the front property line. So that automatically creates an unusual circumstance with this property. And what the applicant is proposing to do is just basically change the back of the house. Currently, it has this one-story shed and some other things back here that have been added over the years. This is the existing on the right and proposed site plan on the left. So you see the existing rear addition, stairs, shed. They're going to remove all of that and replace it with a new addition to the back of the house that squares off the back of the house and provides a more attractive set of stairs for access. Close-up view, upper floor. Again, you see how it has that odd acute angle for the rear wall. Existing and proposed. So here we have proposed rear elevation and front elevation on the bottom, and existing on the top. And then side view. So you see these additions that were added to the original house. Those would be replaced with a much more attractive rear addition. And that rear addition will be an extension of the non-conforming setback and rear setback. So our recommendation is for approval for this request. We feel that they meet the special exception test for this approval. And it's our understanding that the applicant, the owner of the property, did reach out to other neighbors and in some cases was not able to contact them. But Penny, I don't believe that we've got anybody signed up who wants to speak in opposition to this request. Is that correct? Penny there? Penny?
I apologize. I forgot I was muted. No, Mr. Batchelder, no one has signed up in opposition to this request.
City recommends approval. There is no opposition. Mr. Morrison moves for approval. Mr. John is not here. Ms. Grass seconds. All in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass?
Aye.
Ms. Richards? Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett is not voting. Mr. Robinson votes aye. The motion unanimously approved. Item number 8, 12 Tradd Street, Charlestown. Mr. Bennett has recused from this item as well. Request special exception under section 54-110 to allow a horizontal expansion, kitchen expansion, stair, hallway, and vertical extension, loft, stair, that extends a non-conforming 1.5 foot north side setback 3 feet required. Request a variance from section 54-301 to allow an addition, stair, hallway, with a 0-foot rear setback, having a 62% lot occupancy, 3 feet required, 35% limitation, existing lot occupancy 55%, zoned SR5. Mr. Batchelder.
So this is a residential property on Trad, just east of, or just west of East Bay Street. And existing historic home that doesn't meet any setback requirements. And they are proposing to make some small additions to this historic home. And these are just a few shots. I'll get right to the drawings here. So they've submitted something just on the lot occupancy, just indicating that lot occupancies for other homes in this area far exceed the maximum 35% allowed by the zoning ordinance. So the lot occupancy request that they are making tonight is not out of character with what you find in this immediate neighborhood. So that's the existing survey. And these are just simple maps and aerial views, photographs of the existing property. And the site plan. So existing first floor site plan is on the top and the proposed is on the bottom. So what requires your approval tonight is this rear addition right here. And so, and especially on the second floor, you see that it's gotten larger from the small utility shed back here. It's become an extension of the living space with some circulation stairs built in. And so it adds a second floor where there is none as well. And that's what's shown on this drawing right here. And then no changes there to affect board. So in terms of the overall plan, here's a view. You see the proposed site plan on the bottom, existing on the top. These are elevations. So I go to, let's see. So well, this shows that proposed two-story addition at the back of the property right there. So that is the proposed change that requires the approvals that are listed on your agenda. And working with these residential properties in this part of the historic district, you often find these situations where the properties are tight and the lot occupancies of the building footprints are quite large. There's not much room to make these old buildings more functional. And that's really what they're proposing to do with this change that is before you. So anyway, I recommend approval of this request. I don't believe there's been anybody that has contacted us who is opposed to this request. And Penny can correct me if I'm wrong on that.
No, Mr. Batchelder, no one has signed up to be opposed. I did receive an email from one of the immediate neighbors, which the owner reached out to, that said that he was supportive, but he may have joined our meeting. John Scott, he said he wanted to speak if he could. He's the owner of 38 Savage.
Oh.
I don't know if he
Well,
actually signed
so-
up or not.
So anyway, we're supportive of this request. And the applicant is on the call tonight if the board would like to hear from him.
The city recommends approval and there is no opposition.
No opposition.
Ms. Grass moves for approval, seconded by Ms. Richards. All in favor signify by saying aye. Mr. Morrison,
Aye.
Ms. Grass,
Aye.
Ms. Richards. Ms. Richards.
Aye. Aye.
Ms. Vargas.
Aye.
Ms. Bennett's not here. Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Next item on the agenda is 8 Fenwick Drive, Old Windermere. Request variance from section 54-301 to allow one-story additions, pantry, porch, carport, shed, covered walkway with a 2-foot rear setback to allow carport with a 20-foot front setback, 25 feet and 60 feet required, zone SR2. Mr. Batchelder.
So this is a residential lot in Old Windermere. And it's a corner property on the corner of Fenwick Drive and Bellevue Road. So when the home was built on this lot, it was built to face the long side of the lot instead of the narrow side, which means that there's no backyard behind the house. And there's a very large side yard on both sides, actually. So this is a photograph of the existing home facing Fenwick Drive. The Bellevue Road is to the left. That's the street on the left side of this picture. And then to the right is very large. This is the side view from Bellevue Road. But to the left of this image is a very large side yard. And apparently there was once a small garage over in that side yard, but that was removed at some point. Now there's just a driveway and a yard. And what the applicant would like to do is construct an addition to the side of the house that adds a carport, carport and storage area. And also this screen porch and walkway, covered walkway that leads from the house into the carport. So that is the nature of the request. In elevation, it would look like this. And these are sketches showing the proposal. And I'll just go back and say that this is, so these are variances to have the rear setback and the front setback for the carport. The applicant talked to the immediate neighbors and obtained some signatures. Sandy and John Techenberg, I think I know who they are. They live across Fenwick Drive. So they would be looking at the garage for the carport. Then that's Stuart Jolly, okay, 4 Bellevue Road. So they are the property immediately to the rear of this house, adjacent to it on Bellevue Road. And then 55 Folly Road, Kimberly here is also across the street and kind of looking at the large side yard that they want to build this addition in. So those neighbors have indicated that they support this request, and our recommendation is for approval.
City recommends approval. Ms. Ashby, is anyone here in opposition?
No, Mr. Robinson, no one is here in opposition to this request.
Vargas moves for approval, seconded by Mr. Bennett. All in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas,
Aye.
Mr. Bennett,
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Next item is 511 Rutledge Avenue, West Side. Request a use variance from section 54203 to allow a dental office on the ground floor with days of operation Monday through Saturday and hours of operation 8 a.m. to 5 p.m. in the DR1F Diverse Residential Zone District. Mr. Batchelor.
This is a corner store building that is zoned residential, like the surrounding residential neighborhood. And it has for many years had a restaurant on the ground floor. This is the location. You can see it from the crosstown when you're driving by or coming down Rutledge Avenue right there. This is a view showing the restaurant that was there for a number of years. That restaurant moved out and the non-conforming use for that ground floor space has expired because it's been vacant for more than 3 years. So the proposal is simply to replace what had been a restaurant with a dental office on the ground floor. The residential units or unit upstairs would remain. That doesn't change. It's just the ground floor we're talking about with this request. And it's a corner store building. So this use we think is certainly suitable. Given that it was a restaurant before, this is probably a less intensive use. So it's suitable for that reason alone, I think. But we recommend approval of this request.
City recommends approval. Ms. Ashby, is anyone present in opposition?
No, Mr. Robinson, no one is present in opposition.
Mr. Bennett moves for approval, seconded by Mr. Morrison. All in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. 683 King Street, Cannonboro, Elliottboro. Request variance from section 54317 to allow restaurant use with 328 square feet of inside patron use area with 1 off-street parking space, 3 spaces required, zone general business. Mr. Batchelor.
So 638 King Street is another corner property, and this one's a King and Line, zone commercially, general business. It's actually the property next door. I don't know why this map shows this one. It's not a corner property, so I take that back. So this is the property in question right here. The corner property is a separate property. But this is a property that has a historic building up front, then this 1-story addition in the back. And they are proposing to use a small part of that addition in the back, this area right here that I'm circling, as a restaurant. So it's zoned for that use. And the property has office uses in the remainder of the floor area, but this area back here is vacant right now. It also has off-street parking, but there are not enough parking spaces that go with this particular space to meet the parking requirement of 3 spaces. So they're proposing the small restaurant, 328 square feet. There's the zoning map showing general business. This is just showing the parking spaces on the property and the area where this proposed restaurant would be located. Photographs, so you can see this 1-story building right here is the space that would be occupied by the restaurant. And floor plan on the interior on the right is what's proposed. And that concludes the application material. So they are requesting this use. And I think given its location and the fact that there are other parking spaces on the site, which hopefully would be able to be used after the office hours close, I think this request, and given the fact that it's such a small restaurant operation, I think that this is a reasonable request for this variance to allow this use here. I think it's a unusual circumstance with this little one-story building and parking, but not quite enough to meet the requirement. So my recommendation is for approval of this request with the condition that the restaurant not operate past midnight. I think they're not sure exactly what they're going to do here in terms of the restaurant concept, but they don't anticipate, I don't believe, operating this restaurant past midnight. And I think that would be a suitable condition, given the fact that this is where it is and located quite a ways from any public parking garages. So that's my recommendation.
City recommends approval with the condition. Is there anyone present in opposition?
No, Mr. Robinson, no one present in opposition.
Mr.
And
Morgan,
I'm wondering if we might want to just allow the applicant to speak. And I'm not sure that they agree with that condition, so I'd like to make sure that they do. Perhaps if the board would allow that.
that's fine. Bring them on.
So I've promoted Ashley Jennings to speak. So Ashley, if you're there,
Can you hear me, Lee?
yes.
Right. Thank you, everyone, for allowing me to speak tonight.
Hold on just a minute, Ashley. Let Lee swear you in, please.
Okay,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please go ahead.
I appreciate you all taking the time tonight. I know this has been a long night and this is the last item on the agenda. But we suspected, actually learned from Mary Hawkins with the Neighborhood Association that this might be a condition of the application. My client, Ben D'Alessandro, asked that we ask the board to consider it without the condition, only because they haven't fully developed a plan for the restaurant yet. As you can see, it's a very tiny restaurant. We're only talking about 328 square feet of patron use area. And we're really only talking about a limit of less than 49 persons in the space, if you could even fit that many because of code requirements with one single exit. The building is part of a horizontal property regime, and so it's only allocated one space legally as part of that regime. So when you look at it from a use standpoint, it couldn't technically be used for anything without a parking variance. It couldn't be used for residential. It couldn't be used for retail because of the square footage. It couldn't be used for a gallery. So anything that is going to occupy the space would require a parking variance. And so we would ask the board just to consider the request without that condition, so that the owners have the owners of the business have an opportunity to really flesh out what they want to do. They've spoke with the other property, the tenants in the property, and they've honored an idea to limit their operations to after those businesses close during the day, so that they're not overlapping with the other tenants in the space, trying to be mindful of their uses. So we would just ask that the board consider it without the condition.
Thank you very much. Any questions for Ms. Jennings or Mr. Batchelor?
I have one question. So Ashley, were you saying that they were considering not opening the restaurant until, say, 5, like after business hours? Is that what I
Correct.
understood?
Correct. They had agreed with some of the tenants to look at the possibility of just doing dinner service and not lunch, so that they didn't overlap with the other tenants in the building.
Gotcha. And this backs up to Barca, is that right?
The building that frames this courtyard, the two-story building, actually backs up to Barca. And you
That's what I
probably, I mean,
thought.
you probably know that also there's the overpass on the other side,
Right.
where there's parking of it, free parking
Right.
available right there.
And Barca, I'm sure, is open till what, 2?
That's a good question. I don't know the answer to that question, but it's zoned to be allowed to be open until 2.
Mm-hmm. Okay, thank you.
Any other questions?
I wanted to ask Mr. Batchelder, what was your reasoning for limiting the hours?
I just felt that it was appropriate. It would not otherwise be restricted from operating past midnight, because it's not within 500 feet of a residential zone district where there's an additional review step necessary to do that. You serve alcohol. So I'll just point that out. I mean, it's up to the board.
So it's not within 500 feet of a residence. Is that what you just said?
That's correct.
Yeah.
Any other questions? Any motions?
I would move for approval without conditions. I think that's I don't think it's really going to affect anybody around there, especially if they're not open until 5 o'clock anyway.
Is there a second to that motion?
Second.
All those in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Robinson votes aye. The motion is unanimously approved.
Thank
Mr.
you.
Very much.
Mr. Robinson, just clarification, that's approval without the condition, correct?
That was correct. That was the
Thank
motion.
you.
Yes. Thank you all for your endurance.
Thank you very much.
Thank you.
Okay.